All rise.
The defendants, David Savino and Michael Sharp, are both charged with armed robbery and murder in connection with the death of Jason Kunstler. My understanding is that the prosecution wishes to proceed under the felony murder doctrine. Is that correct, counsel?
Yes, Your Honor. The death of Jason Kunstler occurred during the course of the armed robbery. So both defendants are responsible for his death under the felony murder doctrine.
Yes, Your Honor, the prosecution's felony murder theory is built on quicksand. There is no underlying felony in this case, so felony murder doesn't apply. No felony, no murder case.
What's wrong with the felony charge?
I'd like to call my client, Mr. Savino, to explain. Mr. Savino, can you explain why you took the phone?
Sure. I thought it was mine. I mean, I just bought it. The thing cost me $950 and then it was gone. I was freaking out, I couldn't find it. And I see this dude standing there with my phone and I was like, did this guy just steal my phone? I was pretty sure he took it, so I took it back. It made sense at the time. I mean, if someone takes your stuff, you gotta take it back, right? I was just standing up for myself.
Right, but didn't the phone, in fact, belong to the victim?
Yes, it did, I guess. But I didn't know that at the time.
Your Honor, my client thought that the phone was his because he saw Jason Kunstler holding the exact same model, and he falsely believed that Mr. Kunstler had somehow taken it from him. He then enlisted the help of his friend, Mr. Sharp, to take his property back. Now, of course, we concede that both Savino and Sharp were mistaken and erroneously jumped to the conclusion that Kunstler had stolen his property, but that doesn't matter. We're prepared to argue that the mistake of fact undermines the very requirement, that is the mental requirement, of robbery. Simply put, you can't be found guilty of robbing someone if you think that you own the property you're taking.
Do the people agree with this interpretation of the mistake of fact defense?
No, Your Honor, we don't. Well, the defense understands the mistake of fact doctrine, but they aren't applying it correctly to the crime of robbery. The mental element of robbery doesn't require that the defendant have knowledge that the property was owned by someone else. The defense's theory might work in a larceny case, but the court needs to remember that physical force was used in this case. And even if the defendants thought that they had a right to the property in question, that doesn't justify using physical force to take it back. They should have just gone to the police instead. You can indeed be convicted of armed robbery for physically taking back property that you think you own.